Hello, everyone, and welcome to Immigration Talk Show. I'm Nipasa, your host for today, and I'm happy to be back. So, welcome once again, friends. We have got a very interesting webinar lined up, and before I introduce you to our guest for today, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. With that said, friends, today we are going to have a very familiar face who has been a part of Immigration Talk Show for quite some time now. And he is an immigration attorney from Dallas, Texas, from SPB Law Firm. So without further ado, help me welcome attorney Chand Parvathaneni. Hi, Chand. How are you doing today?
Hello, Nipasa. How are you? Pretty good. And thank you for inviting me again on this show. Hopefully, we'll have a very good discussion today about some of the current topics on the immigration side as it pertains to the employment based immigration.
Absolutely. And it's the H-1B season, so nothing better than our topic of discussion for today. Yes, friends, today we're going to discuss about H-1B RFEs on the rise this year, 2025, and what it means for the March lottery. And of course, Chand is going to be here to answer to all of our questions, mine, yours, and you can participate in this webinar by commenting. So wherever you're watching us, you can put your questions in the comment or even join us on call. Actually, you can call us on this number 425-436-6335, and the access code is 988-888. There is 8 5 times, so 988-888. Join us and it'll be very nice. So Chand, what can folks out there expect from today's discussion on this topic today?
Sure. So we have a new administration since January, and a lot of things are changing because, again, anytime a new administration comes into office, because they do things a little bit differently. And right now, the Trump administration, they're kind of refining all the processes, not just in immigration, but across all the federal agencies. And what that means is we will see things a little bit different. And on top of it, the Biden administration, while they were leaving office in December, what they have done is they have changed some regulations. They came up with strengthening and modernizing H-1B regulations, and they came out with a final publication of a rule where things from January 18th they got changed a little bit. So now we have these new regulations that the previous administration finalized that started in January. And then on top of it, we have a new administration where they're revamping and re-looking at their own processes. And what that means is we are seeing different kind of RFEs. We have started seeing new RFEs, new ways of USCIS adjudicating things. And on top of it, based on the current administration's priorities, we know that a few things will change. And we will use this opportunity to see today discuss what is changing, what are the new kinds of trends we are seeing in terms of new requests for evidences for H-1Bs. And since the new H-1B lottery will start in about a few days, it's starting on March 7th. So we're just a few days away from March 7th. So we'll also talk about what people can expect once the lottery starts and once the lottery is over, what they can expect and how we can do things to make sure we are in compliance with the rules and regulations of USCIS. We are in compliance with the requirements, and people do things the right way. And by doing things efficiently, they can at least try to aim for an approval because this process is pretty expensive. The whole application for H-1B, the employers have to spend a lot of money. They have to pay a lot of money to the government. And on top of it, the employers also have a burden of ensuring that they comply with a lot of federal regulations.
Right. And so, friends, thank you so much for joining us once again. You can follow us and don't forget to hit the bell icon. We are on YouTube and our handle is at Immigration Talk Show. So, yes, subscribe to us at Immigration Talk Show. Also, check us out on Facebook, LinkedIn, Instagram, and also on X. All right, so now let's not wait any further. So my first question to you, Chand, is, that there are so many reports out there saying and speaking about the increase in RFEs for H-1B petitions, especially this year. So what do you think are the main reasons behind this trend?
Sure. So in the last 1 month, we definitely saw a little bit of uptick in increase in RFEs. I would not say that we are drastically seeing a huge increase, but I definitely can say that at least for the H-1B petitions, we are seeing new kind of RFEs, and we are seeing a little bit increase in the number of RFEs. And I think the primary reason for that is definitely the new H-1B rules that came into effect in January. So this stemmed from the final rule where they published these regulations, uh, stating that they're strengthening and modernizing the H-1B regulations. And a part of these rules, what they've done is they're focusing more on the bona fide nature of the job. So in terms of focus on added focus on that, nowadays they're requesting for contracts. Now you have to show the contracts, you have to show the purchase orders, you have to show the content of the purchase orders, and client letters, vendor letters. So this new requirement, I think, is causing USCIS to issue new kind of RFEs. So they're coming back and saying that the old memo, the memo that got issued in 2020, so in the RFEs they're stating that this memo has been rescinded, and now they are asking for some additional evidences. So that is where we are seeing some increase in RFEs. And then we're also seeing increased RFEs for proof of maintenance of status. So if a company has applied for a H-1B in the past and that same employee is getting filed for an extension, one of the things that USCIS will see is whether that employee has been maintaining his prior status. So there is a lot of focus on USCIS's side where they're actually looking and asking us to prove that the previous petition, the employee has followed the terms of that petition. And what that means is, if it's a transfer, the employee has to work with the previous employer. He has to have pay statements. He has to be in that particular role. Or if amendments are required, amendments have to be filed timely, and so on. So USCIS has been definitely scrutinizing what employee has done in the past. So before applying, so the previous H-1B petition, has the employee been working as required, and so on. So we are actually seeing a lot of scrutiny on that. And the reason for that is this new rule, the regulations that went into effect in January. They actually talk about ensuring that the employee has maintained his prior status. So that's also is contributing to this trend. And on top of that, the new administration, because of the new administration's way of looking at things. So again, they are looking at employer-employee relationship in a different manner. They're looking at wage level discrepancies in a different manner. If it's a wage level one, so we're seeing an uptick in RFEs where USCIS is questioning the wage levels. And in general, because USCIS, as they kind of look at their own data, they want to prevent fraud. So there are increased fraud prevention measures, and a part of that, what USCIS does is they have something called vibe check, validation instrument for business enterprises. So it's their database where they cross-reference employers' information. They look at their data. They look at the data that's coming out in the I-129. They want to make sure employer is legitimate, the number of employees, the revenue of the company, and so on. So they have their own internal database, a vibe database. So they check against that database. So as a part of increased fraud prevention, we are seeing RFEs which specifically talk about vibe, where they say that things don't match up, things don't line up. So they ask for more information. And so this is another reason why we are seeing a little bit more uptick in the number of RFEs. And then overall, I think I would say this whole H-1B modernization rule and the codification that went into effect in January. So the USS officers, they're also having to look at this new modernization rule and look at things in a different manner. So initially, what that means is, because even the officers are new to this rule, so sometimes the likelihood of RFEs increases, which I think is what has happened. And all these factors have contributed to the rise in RFEs in the last 1 2 months.
Exactly, and I think it was 17th of January, right? Many things, many new updates started, and these new rules also apply. And the lottery is going to start up in about just a week or so. So there's a lot of
Yep.
changes and things that you have to keep in mind. So maybe you could give out a few tips, Chand, for folks out there who are going to participate in the lottery.
Sure. So again, the good thing about the lottery this year is it is beneficiary centric, and what that means is 2 3 years back, we had a lot of issues with multiple registrations, and multiple registrations means some companies are colluding together because the companies are owned by the same set of individuals or their relatives, and the companies are colluding together, and they're trying to increase the chances of somebody in the lottery. So that was giving some people unfair advantage. And what USCIS has done is they went back and forth. They changed the rules last year. So now it's a beneficiary centric process. And a beneficiary centric process means even if an employee has multiple legitimate job offers, say Microsoft is filing for him, Google is filing for him, Apple is filing for him, whether a person has one job offer, has multiple job offers, the chances are exactly the same. So this is a good thing. So what that means is no matter how many job offers somebody has, the chances of getting selected in the lottery is exactly the same. And what that means is it will definitely prevent fraud. It will definitely prevent collusion. So that's a good rule that went into effect last year. And after that rule went into effect last year, the number of registrations dropped dramatically. So they almost came down 50%. That's what happened last year. So that's a good thing for all the folks out there who are getting the registrations ready by their employers, because nobody's going to get any unfair advantage. So everybody is on the same level field, which is a good thing. The only drawback this year is the registration fee. Last year the employers were paying $10. This year the employers have to pay $215. So that's a big hit. So employers will have to pay a lot more for the registration this year. In a way, that's really bad, because some employers might be discouraged even if they have a good employee, because if the employee does not get picked up in the lottery, the employer will not get that money refunded. So the money is gone. So whether somebody gets selected in the lottery or not, that $215 that they have to pay to USCIS is gone. So for that reason, some employers might not really be willing to spend that money unless they know, hey, my employee is going to get selected in the lottery, and it's a good use of money. So for that reason, I do think that the number of registrations might come down. But the other side, the positive side, is that anybody who's just trying to register just because it is cheap, they will not register. So at least the good thing about $215 registration fee is only if the employer is really serious, they know that the employee is highly qualified, they would not get them into the lottery. So there are positives and negatives about this new $215 rule. But in reality, what I think would happen is you will definitely see a decrease in the number of registrations. Last year, because of the new rule, we already saw the decrease in registrations. But last year, I think it was a good rule because it eliminated the multiple registrations problem. This year, we have to wait and watch. But one thing I can say based on my discussions with our clients is this year clients are going to, I mean, the employers are going to file only if they're really serious of that employee, because it's an expensive process this year compared to the $10 they were paying last year. And in terms of suggestion, employers, I think, should file only if they have a bona fide job offer. If they don't have a bona fide job offer, they should not be getting into the lottery because it's an expensive process. And not only that, they're going to waste somebody else's slot. Number one. Number two, people have to make sure they have a valid passport. And not only that, they have to make sure they're entering the right passport, the right information. If there are any typographical mistakes like date of birth or passport number or anything, tomorrow USCIS could come back and cause a problem when you finally apply for the H-1B. For this reason, people have to be very, very careful when they are doing the registration. Make sure the data is accurate, the passport number is accurate, the names are accurate. And if somebody's passport is not valid, has expired, or about to expire, make sure that you apply for a passport renewal right away, because for a lot of countries there are ways to expedite passport. So people can, if somebody's passport is expiring, there are ways where somebody can quickly get a passport. Like for example, in India there is Tatkal, so people can get a passport in about a week. So anybody whose passport has already expired or is about to expire, it's a good time, well ahead of the lottery deadline, they should go ahead and get their passports renewed. And one final advice is there is something called master's quota and regular quota when they apply for H-1B registration. People have to be cautious. And if somebody marks it inaccurately, they make a mistake and they put somebody's quota as master's quota when they don't qualify for master's quota, that H-1B registration will be invalidated. So always make sure that if somebody is getting put in the master's quota, verify the name of the university, make sure the graduation date, and so on before putting somebody in the master's quota. Okay, so again, the registration part is pretty simple. Again, if things are the data is accurately input, it's a very simple process. And before March 31st, the lottery selection will be done, and then the actual filings will start.
Very, yes, thank you so much for those wonderful tips, Chand. And I'm sure that folks out there are liking all these tips since, H-1B lottery is really knocking at the door, almost the season now. And talking about the fees, $215, it's a huge hike, 200% almost or more. So, what do you think is going to happen with the money, that US is going to accumulate with this, the registration process?
Sure. So USCIS is a self-funded agency, and what that means is they're not really relying on the government for the funds. They are self-funded. So basically, they generate their own revenue and they use it for immigration purposes. So what that means is, again, the money is not going into private hands. It's going back to USCIS. So hopefully that money is required to be spent for USCIS purposes. And what that means is they use it for hiring, they use it for making the processes more faster, more efficient, and so on. So normally when we hear about any government shutdowns, typically USCIS is not impacted because they have money. So the $200, it's a huge money, and hopefully USCIS will use that money to refine their processes and make things a lot more smoother for others. But again, even if they get 200,000 applications, which I think they will definitely get this year, because last year they got 400,000 registrations. So 400,000 registrations at $10 for each registration, that's equal to about $4 million. This year, $215 times the number of registrations. So it'll be a couple of millions of dollars. It's a huge amount that USCIS will be getting, but hopefully that money is being spent for modernizing their computer systems, making things more efficient, which is what eventually will happen with that money.
Absolutely. Thank you so much, Chant, for taking that up. And, at this moment, I would just like to say hello to all our folks who have joined us with their questions as well. And also everybody out there who are watching us. Thank you so much for joining us on Immigration Talk Show. Please don't forget to subscribe to us if you haven't as yet already. And our handle is at Immigration Talk Show on YouTube. We are also on LinkedIn, Facebook, X, and on Instagram. So check us out, follow us, connect with us. All right, so hi to Nandini, Rag. Rag says hello, Nipasa and Chand. Hello, Rag, one of our very frequent viewers. Always good to have you. So, Rag, if you have any questions, also please feel free to comment. Also, hello to Geeta, Reddy, Abha. We are going to take up your questions. Please stay with us. All right. So now, Chand, my next question to you is, you know, there are probably certain job categories or industries who are seeing a higher rate of RFEs compared to that of others. So, if so, why is it like that?
Sure. So when we talk about H-1Bs, the majority of the H-1Bs go to the IT and the tech industry because the tech jobs are or who use the H-1Bs on a large scale. So when we talk about just the numbers in general, normally the IT and tech industry is where we typically could see more RFEs. The other industries that use a lot of H-1Bs are nowadays a lot of the pharmaceutical industry, the semiconductor industry, healthcare industries. They're also using a lot of H-1Bs. And normally, my uh, experience is healthcare occupations typically have very, very low rate of RFEs. And the reason for that is since COVID, I think the general consensus has been that healthcare is pretty, pretty important. And USCIS normally they tend to do healthcare petitions a little bit quickly, and healthcare I typically don't see issues. And after COVID, a lot of focus has come down to bringing industries back to US, which means the pharma industry and the chips, the semiconductor industry. So we're seeing a lot of jobs come back to US, at least a lot of validation engineering, the pharma jobs, and the semiconductor, those kind of jobs coming back into US. Those also we typically don't see a lot of RFEs in general. And even within the tech industry, if it's a staffing kind of a company where you have an end client, so basically you have a situation where employee is an employee of a certain company, and through a vendor they're working for another end client, and the end client is somebody else. So those are the kind of areas where we tend to see a lot more RFEs. And I mean, again, historically, anytime you have a consulting or a staffing kind of an arrangement, they definitely face higher volume of RFEs. And the reason for that is, for the last 15, 20 years, always USCIS goes back and forth with this employer-employee relationship. If somebody is a full-time employee, the employer-employee relationship is pretty easy, very easy to establish. But when you have this situation where you have in the consulting world and the staffing world where somebody is working at the end client, the employer-employee relationship is a little bit difficult to establish, because who's giving the direction for somebody's work, who is directing and supervising somebody's work, and so on. It becomes a little bit hard. And then in 2020, we had a lawsuit, and USCIS came out with this memo. And ever since, employer-employee relationship became a little bit easy. But again, in the new modernizing rule, again, things are a little bit different because that old memo was rescinded. And what that means is consulting and staffing companies can anticipate RFEs even going into the future. And again, the lesser used industries like education positions, research positions, a lot of universities use research positions, creative positions. So those kind of fields, I do think that we will not be seeing a lot of RFEs. And staffing kind of roles, and even within the staffing roles, so there is something called own it. So every H-1B that gets filed, you have to map it to an own it occupation, you have to map it to an own it code, you have to also give the wage level. Normally what happens is, when the wage levels are low, or some particular occupation, some particular own it occupations who don't really have a bachelor's requirement, when you look at the occupational outlook handbook and look at the requirements, those are the ones you typically will always see a lot of RFEs, because specialty occupation is something you have to prove on every H-1B petition. And some own it codes, by the nature of their data, by the nature of their occupation and how it is in the occupational outlook handbook, the USS will routinely come back and say that is not a specialty occupation. Okay, so high level, some industries are always a target, and even within the industry, some own it codes are always going to be problematic.
Okay, Chand, thank you so much for taking that up as well. And I think we should take up a few questions from our audience right now so that they do not wait too long. So let's take up Nandini's one. Nandini is asking, I have an IT consultancy offering me an H-1B, but I heard that USCIS is increasing RFEs for third party placements. How can I prove that I have a valid employer employee relationship for the entire duration of my visa?
Sure. And so again, ever since we have this H-1B modernization rule in January, so the way USCIS is looking at third-party placements has changed a little bit. So they even modified the I-129 form. So now you have to actually put the end client name and a few things about end client on the I-129 itself. So this is a new thing, and it was not there prior to January 18th. And how do you prove? So again, because we have done a lot of filings in the last 1 month, and what we are seeing is, so the way you would prove the employer-employee relationship is, you have to initially prove what your assignment is. And what that means is, if it's a third party assignment, like in your case, you have to produce the purchase order, you have to produce the statement of work, or you have to produce the vendor letters, or you have to produce the client letters. One of these documents. I mean, again, USCIS does not say this is mandatory or that is mandatory. It is the company that has to prove the bona fide nature of their assignment. And if they're able to establish the nature of their assignment, USCIS does not have a problem, because staffing is allowed, consulting is allowed. And the purchase order, even if it is not for 3 years, because it's very hard for every employer to have a 3-year purchase order. So even if it's a short-term purchase order, at this point of time, we are not seeing any issues with USCIS. However, what USCIS wants is, do you have an assignment on the day of filing? Whether it's a 6-month assignment or a 1-year assignment, as per the purchase order, that's okay. But you do have to prove that on the day of your filing, you do have a valid bona fide assignment with a third party, with the end client. And how do you prove it? The easiest way is, the company will sign a purchase order or a contract with somebody, and you use that to prove that you have a valid assignment. And if you're able to show that, we are not normally seeing any issue. So if somebody comes to us and says, hey, we don't have any contract, but we want to place somebody on a project after we do the filing, that cannot be done. On the day of filing itself, you need to have a bona fide assignment, which means on the day of filing, you need to have the contract signed. So if that is the case, in general, you should not have any problem with employer-employee relationship, even in the current new rules.
Okay. Thank you so much, Chand, for taking that up. And Nandini, I hope you've gotten your answer. Thank you for participating. Now, next up, we got Geeta Reddy asking, I heard USCIS is scrutinizing specialty occupation criteria more than ever. So, my H-1B job title is Market Research Analyst, and I have an MBA in marketing. Could this raise red flags, and how do I prepare for potential RFE?
Sure. So, market research analyst, that particular ONET code, historically it had a lot of problems. And if you Google, you'll see a couple of lawsuits filed for USCIS denials on marketing research and analyst positions. And in 2000, I think it was like 2020 or 2019. So there was a lawsuit where the court said market research and analyst. I mean, it is definitely a specialty occupation position, and in general, it is prone to RFEs. But again, we are not seeing challenges in the last couple of years if the duties require a bachelor's degree. So again, in your case, you said you have a degree in marketing. Your position is market research analyst, and if you look at ONET, market research analyst on an entry level also requires a bachelor's degree in a specific field. So more than likely you'll be fine. But historically, we did have challenges with that occupation previously, a couple of years back. So even now, as long as the job duties are detailed and there is a nexus between your degree, your qualifications, and the job duties, and the job duties do require a bachelor's degree or above, and in your case you have a master's degree with focus in marketing, so more than likely you should be good. And this is a field that is prone to RFAs, but again, if you're able to prove, you should not have any issue.
Okay. Thank you so much for taking that up for Geeta. Geeta, thank you for participating. And well, Rag is also here with a question. So, Rag is asking, with the current state of RFEs, will it be better to go for a blanket L1A instead of the individual N1A provided the company is eligible for both?
I mean, I would go with individual L1A rather than a blanket L1. The reason is, if you go with an individual L1A, if you get an approval and everything looks good, tomorrow, normally what companies do is the companies look at explore the EB1C option. So I would say, if the company has a blanket L1 and you're also qualified for individual L1A, L1 can be done in premium. So to me, it's always worth taking that extra effort and trying for an individual L1A, because if you get an approval for L1A, you're able to prove, you're basically proving that you're a manager on the offshore entity side. You're coming here to work as a manager on the US entity side, and tomorrow you use that to explore EB1C options. And EB1C option is a great option to explore. Not a lot of people qualify. So when you have the chance, I would always say that, like, maybe you should take the harder route. Look for the individual L1A. The good thing is it's possible to do it in premium, so you'll get a quick answer. And if the company has L1s, blanket L1s, I'm pretty positive that the company is a huge company. It's a big company. So based on your role, definitely, I think I would say try for L1A, and if you get through, EB1C becomes a great option for you.
Thank you. And Rag, thank you for participating as well. I hope you got your answer. And next question, this is from Abha. Somebody with family preference AOS already filed. Can their employer apply for H-1B? Things that need to be kept in mind given the pending AOS. And when you say staffing companies and consultancies, does it also include consulting companies like EY, McKinsey, etc.?
Yeah, yes, technically, even they are consulting companies, and in the past, before 2020, even they had denials for H1. And if you look at, like, just Google Infosys or TCS, Infosys got a huge penalty, I think, last year for immigration. TCS, I think there is an issue about TCS. Recently, I think it's in news. about some issue that they had with immigration. So even big consulting companies could run into issues. That being said, it's not about uh, the consulting company or not. In general, whenever you have a consulting company and you're saying that your employee will work at a third party location, the rules are a little bit different. The analysis is a little bit different. So, I mean, a small company, I mean, I have seen lots of small companies with one or two employees not have any problems with their H-1B. Sometimes big companies could have a problem, or big companies might not have a problem. So the whole thing is, it is what exactly is the assignment. So the big companies, if they're able to prove the assignment, they'll not have a problem. And even if it's a big company, if they're not able to prove what that assignment is, they will have a problem. So, but again, in general, whenever you say it's a third party kind of an arrangement, in the new rules, in the new I-129, they are actually asking for that information on the I-129. And what that means is whenever they see that it's a third party kind of an arrangement, the analysis will be a little bit different. But again, if it's a big company like E&Y, McKinsey, normally they have a valid assignment, they have valid bona fide assignment. So it's a lot easier for them to prove when you're a big company. But again, in terms of USCIS officer looking at things, yes, even big companies get RFEs. Even again, it's just a part of their job. So every case is different, and the occupation for the case is different. The salary they're providing for that case is different. So all these things will contribute to the H-1B. And going back to the other question, so you have a pending AOS. Pending AOS means based on your family relationship, somebody has filed for a green card. You can always pursue a H-1B even if you have a pending AOS. So even if you have a pending green card application, H-1B is a dual intent visa. So you can have employment based H-1B non-immigrant visa processed simultaneously along with the pending family AOS. It's completely legal. And what I advise is it's always better to maintain your own status until that other AOS application gets approved. Because if something were to happen to that AOS, H-1B is your backup. So legally, you can pursue both. So you can stay on H-1B while the pending AOS application is in progress. The only thing is, if you're on H-1B, you have to make sure you're following the terms of H-1B, which means you are working as required, you're getting paid as required, you're staying in the same metro where you're working. So all these requirements about H-1B. So as long as you maintain valid H-1B status, you comply with the rules of H-1B. Having a pending AOS will not cause you any problem, and it's actually a good idea. If you have a pending AOS, pursue it in a legal way, and be on H-1B until that case is approved.
Okay. Thank you so much, Chand, for taking that up for Abha. And right now, I think I would say that we should go for a short break. But we also have Sanjay who has joined us with his questions. Sanjay, stay with us. We will take up your questions after the break. And Chand, I also have some more questions from my end. So for now, we'll just go for a short break and be back on Immigration Talk Show. Folks out there, don't go anywhere. Stay with us. It's Nipasa and Chand. Hello and welcome back, everyone, to Immigration Talk Show. I'm Nipasa, and today we have a very interesting webinar with none other than Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas, and we are discussing about H-1B and the most common RFEs this year. And he's also giving out tips on how can we prepare ourselves for this upcoming lottery, the March lottery. So thank you so much, Chand. It's been great so far, and also folks out there for joining us. Abha, and we got Rag, Geeta, and Nandini. And also, let me tell you that if you're enjoying this session, do not forget to subscribe to us. Our handle is at Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, X, and also on Instagram. Do check us out. And also, if you want to contact Attorney Chand Parvathaneni directly, have a one on one consultation, maybe have him guide you for your H-1B this year, call him on this number 817-523-8247, and you can also email him at law@spblawfirm.com, and do go visit www.spblawfirm.com to get to know more about Attorney Chand Parvathaneni. So, also, friends, you can join us on call. Why don't you call us? I mean, Appa or even Rag, maybe even anybody out there who's watching us. Why don't you join us on call to ask your questions yourself? 425-436-6335. That's the number. And when they ask for the access code, dial in 988-888. Okay, so I was saying after the break, I'm going to take up Sanjay's question. Sanjay is asking, I work in STEM field, but my job requires a mix of technical and managerial skills. If USCIS issues an RFE asking for proof that my role is a true specialty occupation, what kind of evidence should my employer provide?
So USCIS has certain requirement on how you would prove a job is a specialty occupation. So the way you would do it is you look at the normal industry standards. So you look at the industry standards for the job. And if you're working at a client location, you look at what your client requirement is. You look at how specialized your job duties are. You look at for that occupation, you look at what the occupational outlook handbook says regarding those job duties. And so there are like a whole bunch of ways you can do it. So you can also get expert opinions from a professor, where the professor will talk about the nature of the job and so on. So USS has a certain requirements. So they have like four prongs that you can meet any of those prongs in general to prove that your job is specialty occupation. Again, the goal is as long as your job duties require at least a bachelor's degree or above in a field, in a relevant field, not like any field. So when I say relevant field, it could be like computer science, IT, software engineering. It could be like different fields, but all of them have to be related to the job duties. So if you say like software engineering, computer science, IT, they're kind of related to the job duties. But if you say mechanical, that's completely a different field. So as long as a set of closely related degrees are required to do your job duties, pretty much that job is a specialty occupation job. And the way you prove it is just looking at the detailed job duties, seeing how does somebody qualify, the industry standards, if you have a client, the client requirements, and so on. And that's how they would do it. And again, if you are in a very technical role, more than likely you should not have a problem.
Thank you so much, Chand, for taking that up, Sanjay. And Ragh was back. He was still asking because okay, he asked, "Thanks, Chand. And are blanket L1A not eligible or tougher for EB1C?"
So EB1C is basically where your company will apply an I-140 on your behalf in that managerial category. So again, when the company applies for EB1C, you don't even require an L1. In general, like L1A is not even required. But what happens is when the company applies for a L1A, as a part of the petition, they're trying to prove that you are a manager in India, you're a manager abroad, and your role in US they will talk about your role in abroad entity, the role in US entity. They'll try to prove all those things. So normally, what happens is you can reuse a lot of that data when you apply for EB1C, because EB1C is again it's like independent application. So whether you're an L1A or not even on L1, the company can still apply for EB1C directly. But since if the company does an L1A, individual L1A for you, the company is documenting all those things, they are getting everything ready. your EB1C normally becomes a lot easier because you have all the documentation ready. You can easily convince your company that, hey, we already have all the data. It's a lot easier. But in terms of eligibility, L1A is not even required for EB1C. EB1C is completely independent by itself, and the company will have to do it independently. So theoretically, even if you don't have an L1A, individual L1A, if you are eligible, the company can still file EB1C for you.
Okay. Thank you so much, Chand, for taking that up. And Rag, I I hope you've got your answer. We also got K. Vishwanathan with a question saying, "Hello, Sam. Hi, K, but I'm not Sam. I'm sure you miss Sam. Sam is going to be back with another webinar at 2 p.m. Eastern Time, so don't forget to tune in to Immigration Talk Show, all right? And I'm sure that this question is also going to be very relevant at that time. But Chand, if you would like to take it up, or maybe you could just briefly answer to K. Vishwanathan asking, my question is L1A visa interview getting into any challenges or hard vetting. I'm waiting for appointment scheduling for L1A2 with family. Should I go alone or with family together?
Sure. So I think starting from January, we are seeing a lot of issues with appointments in India, and they've been canceling appointments. And again, like 2 weeks back, they actually announced and changed the rules for Dropbox. And what that means is more and more people are required to go for interviews, and we are seeing challenges where appointments are getting very, very tough. And we also heard some news about 10% of the staff at Department of State, so at the consulates, could be reduced in the next couple of months. And what that means is the staff gets reduced, and now the Dropbox appointments, people are not getting Dropbox, but they're mandated to go for in-person interviews for a lot of other visa classes. All of these are going to like create more challenges at the consulates for your interviews. We expect things to slow down even further. And what that means for you is keep checking the website, and rather than go with the family, try to book an appointment for yourself. The minute you get an appointment, try to at least get your appointment done. And unfortunately, because so many rule changes, so many staffing changes, uh, getting appointments could be tricky, could be taking longer. And to me, if you ask me, definitely go. You as the primary applicant, I think you should go get your visa first, and then the minute the family gets their appointments, they can go for their appointments.
Thank you, Chand. Thank you. So he also is asking another question. Kay, what's your thought? He's saying, "Hi, Chand. What's your thoughts on L1A staying in same city as mentioned in I-129 petition, or take risk to move to another city, but I work legally and justice to my job and organization and my client."
So this is again something you might have to talk to your company, because you have to make sure you follow the terms of your petition. So whatever the company's petition is, you do have to follow the terms of your petition. So just make sure you check with your company, and if you got an L1A, you're probably working at a big company. So and again, the company will know what they've done in their filing. So as long as you maintain the terms of your petition, you will not have a problem. So you cannot do anything that is violating the terms of your petition. You cannot have material changes. So just make sure you check with the company and see what they have filed, what they have notified USCIS. And as long as you maintain the terms, you should not have any problems. If you have any material changes, typically that's when you could have issues.
All right, Chand. So, thank you for taking that up. And Kay, I hope you've got your answers. Also, like my next question to you, Chand, would be, if you could tell us about specialty occupation again, and what specific documentation can H-1B applicants provide to avoid or effectively respond to RFE related to specialty occupation issues?
Sure. So when you talk about specialty occupation, you have to convince USCIS that that particular job requires at least a bachelor's degree or above in a particular field. That is pretty much what you're trying to prove when you apply, when the company applies for your H-1B. So in terms of what you can provide upfront to avoid these kind of RFEs, the first and foremost thing that you should do, your company should do, is they should give a very, very detailed and elaborate explanation about your job duties. And normally where I see an issue is some companies are giving only 5 or 6 lines of the job duties. And if the job duties are not clear, not very elaborate, that's basically your biggest risk, because USCIS has to know what your detailed job duties are. You're asking for a H-1B for the next 3 years. And what that means is be as elaborate as possible. To me, that means maybe 2 or 3 pages of detailed job description. Put percentages. Okay. So what that means is, say you're working on client calls, and so client calls don't require like any education. So you have to be very very specific. If you say client calls, you're calling the client, you're getting on the client calls to discuss about technical requirements, for example. So you have to detail your job description. You have to put percentage, how much time do you spend, because you have to spend your time on complex tasks, specialty occupation tasks. So give as detailed explanation as possible about your job duties, very elaborate description. Put the percentage of time that you will allocate. Okay, just don't give some random duties, but very clear, and give a very clear picture to USCIS on how your day looks like, or how your week looks like. Maybe 40% of the time you're spending on software development, 10% of the time you're spending on software testing, 10% of the time on requirements gathering for your technical product, and so on. So uh, elaborate job descriptions with percentage allocations is the first and the foremost way that you go to USCIS. That's first thing. Second thing, again, if it's a third party client, if at all possible, try to get vendor letters or client letters where the client or the vendor, they talk about the education requirements. So if the client comes back and says, hey, for doing these job duties, our normal requirement is so and so degree in so and so field, that adds a lot of value. So what you should be doing is, if it's a third party client kind of an arrangement, get a letter from the client, get a letter from all the vendors discussing the education requirements for doing this job. So that will give a very good clarity to USCIS on what kind of a job, what kind of an education requirement you need. And the other thing is your employer themselves actually telling USCIS what the education requirements are, their normal practices are for that particular role. That is also very important. And again, some employers go ahead and submit some kind of proof upfront, maybe like a expert opinion from a professor, or maybe some of their prior hiring history, and so on. But on a high level, at least the basic these basic things have to be tackled upfront. And on top of it, you have to use the right ONET code. So when you use the right ONET code, good practice is to also include the occupational outlook handbook documentation, because the occupational outlook handbook documentation, or Bureau of Labor Statistics, their reports, they clearly show for this occupation what is the standard. For example, if somebody is a software developer, the industry standard is a bachelor's degree in computer science, or a very close field of computer science. But if you see something like basic web developer, for example, if you look at occupational outlook handbook or ONET, the general requirement is not a bachelor's degree. So including those documents upfront as a part of the filing, showing the ONET code, showing what the occupational outlook handbook requirements are for that ONET code, that upfront will tell USCIS what that requirement is. So these are some of the things that you do to reduce the risk of specialty occupation RFE.
Thank you so much, Chand, for taking that up. Now we have Galela, who has another question for us. Hi, Galela. Thank you so much for joining us. I wish you can also join us on call. If you can, dial this number 425-436-6335, and the access code is 988-888. So Galela's asking, do I need to mention about my green card application in DS 160? Perm process just started. I have a visa appointment in May 2025. I am on L1B right now. I am in USA changing H1B, same company.
So the question that the DS 160 asks is, do you have an immigrant petition filed on your behalf? So perm is not the immigrant petition. So if the perm has just started, your immigrant petition has not been filed. If somebody's I-140 has been filed, I-140 is the actual immigrant petition. So if the I-140 is filed, you would always mark it as yes and give information about your immigrant petition. But if the perm has just started, the perm is just a Department of Labor application. So perm is not really an immigrant petition. The I-140 or the I-130. So for family-based folks, I-130 is filed, or for employment-based folks, I-140 is filed. So, and for like investors, like EB5 investors, I-526E is filed. So if one of these petitions are filed with USCIS, that is when you have to mark it on DS-160 and notify the Department of State, the consulate, that an immigrant petition has been filed. But if it's just the perm is not really an immigrant petition, so you don't really have to put that on your DS-160.
Thank you so much for taking that up. Galela, I hope you've gotten your answer. Rag is back with another question asking, I am in current light. Could applying as a third country national work if consular appointments are not available for work visas?
So be cautious about the third country nationals, the TCNs. So what is happening is now all pretty much like every consulate is overburdened because of so many people trying to apply for visas in the last couple of months. So even before President Trump started, there was a talk that people, I mean, I guess people thought that things will slow down. So there were like countries like Mexico. We saw a lot of challenges. Even in December, November itself, people were finding it very, very challenging to get an interview appointment. So, and what this I mean, these foreign consulates, a lot of these consulates, if you're not a resident of that country, they tend to prioritize things for their own residents. So the rules for the consulates keep changing very, very frequently. So you would have to actually call the consulate or talk to the consulate and look at the rules. We had a number of cases where at the last minute appointments got cancelled. So whenever you're in a third country, uh, be aware that the third country, every the consulate, they can make their own rules. So things keep changing. For example, if it's Mexico, if it's first time H-1B stamping, they don't do it for TCNs. If it's Canada, they're doing it. And again, within the country, you have multiple consulates. So the answer for you is you would have to personally check with that consulate's requirements, because the consulates don't have uniform rules. So every consulate is different. And if you're not really a resident of that country and you're going to a third country as a third country national, they may or may not accept you.
Okay, thank you so much. And okay, Kay is saying, just for your information, my friend I-129 is approved, say 131 and 310 in his family visa interview. So about 20-30 days lag for now, I see. I'll update next week the dates I get for myself. Okay, thank you so much for the information, Kay. And I think, yeah, Chan.
Yeah. And again, what I see with the dates is all of a sudden the dates get opened up. So I think you have to constantly look for the dates because they open up dates and then you have to take appointments. And again, right now I can tell that there is a lot of demand for appointments. The reason is this whole Dropbox, the way they change the Dropbox rules. Now they're saying that majority of the people have to come for in person because a lot of people who used to be eligible for Dropbox, they simply never had to go for an appointment. Now those people are having to go for in-person interviews. So so you'll have challenges, but again, keep constantly looking at the slots. The slots will open up at random times, and then you just have to book a slot whenever they open up.
All right. Thank you, Chand, for taking that up. And with that, I think we should also take up a few questions from our Facebook groups, if that's all right with you, Chand. Control if you can display,
Yeah,
please.
sure.
This is Brinda asking, hi all, I have H-1B visa started on 10/2022 and expiring it on 10/2025. When should I apply for extension?
So one can only apply for an extension when they are within the 180-day time period. So if it is 10/2025, 6 months, so basically April 2025. So from April 2025 till October 2025, during that 180-day period time, extension can be applied. And our recommendation is applied as quickly as possible. So what that means is, in April, she'll be eligible because that 180-day, the time window will start. So as quickly as possible, which means April or May, it's a good idea to finish off the extension part.
Okay. Thank you for taking that up for Brinda. And Kay says, wow, as we chat, I got my soft copy for I-797B. That's really nice, Kay. Congratulations. All right. So let's go on to our next Facebook question, Control. If we can have that. Yes. So this is from an anonymous member, Chand, asking how much usually the cost for H-1B extension, H-4 extension, and first time H-4 EAD with average attorney fees. Company is small scale business, less than 25 employees.
Sure. So the H-1B extension, so I'll tell you the fees. So for a company that is less than 25 employees, the first time they file a H-1B, it is 2010 dollars. For the first extension, they have to pay $500 less. So it is 1,510. So 1,510. That's the first time extension fees. And the second time, it gets even lower. So the second time, the fees is even lower. It decreases by another $750. Okay, so that's the USCIS fee. And then when it comes to H4, the USCIS fee is $470. EAD again has its separate fee. EAD, the fee is $520. So you're looking at about close to $1,000 for H4 and H4 EAD, just the government fee. And then that attorney fees, I mean, typically you'll start seeing from $1,000 for the H1. And depending on what your company is doing, whether they're doing it in house or they're using an attorney, the price could differ. But in terms of the USCIS fees, those are the constant fees for anybody that has less than 25 employees. Once they cross 25 employees, the fees increases a little bit with USCIS.
Okay. Thank you so much, Chand, for taking that up. Now, our next question is on the screen. This is also from an anonymous member. I received my I-120, I guess. I want to prepare myself for the interview. Why is the best question about why USA? What can I answer about I want to finish my studies now because I haven't studied for years? How can I answer this question and how can I convince her? I want this really. I got rejected twice before, and the second reason was that I wasn't proficient with English.
Sure. So I think so when you go for an interview, I think for an F1 interview, the officers are looking at two main things. One, what is your real intention? Are you coming to study and follow the rules of F1? That is the first thing. The second thing is your intention to go back to your home country after your studies are done? So the focus will be a lot on these things. And what that means is so they have to be able to convince that they have ties back to their home country. So they have to show through evidence what their ties are to their home country and why they would come back. That is very, very critical. And the other part is what exactly are they studying, how it will fit in their career plan, and what exactly is their goal. So once they finish their studies, what exactly is their goal? And if somebody is not able to articulate the reasons for studying, the reasons, their future plan, normally we see issues. So the thing is, you have to be able to articulate and explain to USA's officer what your the nature of your study program is, how it would fit in your career aspirations. And everybody's case is different, so that and everybody's program is different, because some people are taking computer science program, some people are taking English as a second language program. It could be different programs. So overall, the nature of the program is very important, and they have to establish their ties to the home country. And again, every officer is different, and the consulate officers have a lot of discretion. And if they deny the case, unfortunately, you cannot get it reviewed, you cannot file a lawsuit in the court. So the thing is, they have a lot of discretionary power. So all that means is that particular office, a lot depends on that particular officer. So you have to be able to convince that particular officer. And if they are convinced that somebody's intention is to come and follow the rules of F1 and then go back to their home country, they are successful. If not, they typically have challenges with F1.
Right. Right. Thank you so much, Chance, for taking that up. And now we have another question. This is also from our Facebook group and from an anonymous participant asking, Hi, I am on an L1B visa and I will be completing my third year in September 2025. My company will apply for a green card, and they said that I should extend my L1 visa for another 2 years and at the same time apply for an H1B visa as the green card process may take more than 24 months. My question is, can I get an H1B visa on a future date? And can I apply now and get the visa after the expiration of my L1B? Or do I have to move to H1B immediately once it's approved?
So again, in the new rules, when I mean, first the first thing is somebody has to go get through the lottery, and if they get through the lottery, the new rules say that you can apply for with a future date. So when you apply, you can put a date that is 6 months ahead of time, and that can be done. And the other thing is whether somebody has to move to H-1B right away or not after the approval. There are two different ways of doing a H-1B, and this is applicable to even students. You can do H-1B as counselor processing, or you can do H-1B as change of status. And if you do it as a change of status from the day, so if you do it as a change of status filing, uh, the H-1B is immediately active from the date of that change of status approval date, validity date. If somebody files a H-1B as counselor processing H-1B, so people can always take some time and they can convert into H-1B in the future. So a lot depends how the company is filing the H-1B, whether they're doing it in counselor processing or filing it directly with change of status request.
Okay. Thank you so much, Chand. So now we have another question, right? Control, if we have, can you please display it, please? Okay. I'm on OPT. I want to travel to India in April, return back in May first week, and my OPT is ending on 17th of June. Did anyone travel from Canada to USA on F1 visa from Montreal Airport to Toronto Airport? My question is, where will be the immigration in USA or pre-clearance in Canada, and they ask? What do they ask for?
I'm not sure if Montreal has pre-clearance. I mean, like some countries, like for example, Abu Dhabi. So you can have customs clearance done in Abu Dhabi airport. I'm not really sure about Montreal, how it works in Montreal, but at a certain point of time, they have to go through CBP, and CBP officer has to be convinced. So a CBP officer, only if he's convinced, they'll grant admission. So definitely, whether it's either in Canada or in US, you have to go through the CBP. Some airports like Abu Dhabi do have the CBP officers in the foreign country itself. I'm not really sure how Montreal does their things.
Okay, Chand, thank you for that. And I think we can take one more from our Facebook group. This is I applied for a change of status F1 here in America and got approved last year. I'm planning to visit my home country, Philippines, this June for my sister's college graduation. Will it be hard for me to come back to America? I've heard mixed opinions from other people that I will have a hard time. Your opinions and suggestions are highly appreciated. Thanks.
So I think the challenge is because it was a change of status approval. So when he goes to Philippines, they have to go for stamping. So I think basically that word mixed opinions from other people. I think it's because when you go for stamping, anything is possible. A lot depends on the officer. So this person has to go for stamping for F1, and depending on the officer, if at all there is a denial, there is a problem. But my experience is if somebody is already studying in US, you have a lot to prove that you're paying your tuition, you're actually uh, progressing towards your degree, you're getting all the pass grades and so on. So most of the time when you're able to show that evidence, I think the office it's easy to convince the officers because this person has already started his F1. He has done a change of status, he's in US, already studying in US. So in general, it's a lot easier to convince the officer showing all these evidences. That being said, it is not 100% guaranteed because the officer will still have to give a visa. Only if the visa is given, he can come back. So that uncertainty is always there until he gets his visa stamping done.
And so the mixed reactions, the mixed opinions, right? Thank you so much, Chant, for taking up all of our
Yes.
questions so patiently. And I have this one last question to you, because there could be chances also that people would not make it to the lottery. So for those who would not be selected in the H-1B lottery, what alternative visa or work authorization options should they explore?
So again, if somebody's in US, most of the time they are in US either on F1. Majority of the time, some people on H4 because they try to convert from H4 to H1, or sometimes people are on L1 and they try to convert to H1. So if somebody is already in US, again, they can continue that status. The only problem is if it is H4, you can't really work on H4 until you're eligible for H4 EAD, which means you're dependent on your spouse getting I-140. If it's a student, most of the time what luckily happens is students still have their OPT period, and some people will be having like STEM OPT and so on. So if somebody is a student, has their EAD card, continue on your OPT as long as you can. Some people, what they do is they extend their F1. They again get enrolled in another program, and if you're doing it, make sure that that college is legitimate. You're actually following all the F1 regulations if you're doing that F1 program. Uh, and for the folks that are not in US but are outside the US, again, in terms of work visa, again, you have the O visa option. So O visa again is a good option even for people in US. However, O visa is very tough. But again, a lot of people have been exploring O visa. So everybody that is not getting selected in the lottery can look at their O visa options. And some folks who are eligible for L1 because they're working in the foreign office, the company is also in US, they definitely should explore the L1 option. So L1 and O1 are actually very good options. And other than that, I think there are not many options for specialty occupation. But if somebody is from some other countries like Mexico or Canada or Australia, there are other options. There are like options called TN visa. There are options called E3 visa and other options. So depending on where your country, where your passport is from, you might be able to find some other options in general.
Okay. Thank you so much, Chand. I'm sure that would be of great help, to folks out there. So, folks, if you resonated with today's webinar, and I'm sure you did, do not forget to, subscribe to our channel. We are Immigration Talk Show on YouTube, and we are also there on LinkedIn, Facebook, X, Instagram. Do check us out, and also go visit www.staffingly.com. And in case you want to have a one-on-one discussion with Attorney Chand Parvathaneni, why don't you go check him out as well? His website is www.spblawfirm.com, and you can also call him on his number 817-523-8247. And it'll be best if you can actually email him with your case, because every case is different and need its own attention. So his email address is what you can note down. It is law@spblawfirm.com. Thank you so much, Chand. And yes, I think H-1B lottery season is knocking at the door. So maybe if you have final words, to folks out there who are watching us right now, it would be great.
Sure. So again, the H-1B lottery, I mean, I definitely think we will have a lottery, but I think the numbers will come down compared to last year. Last year, we had 400,000 registrations. I definitely think the numbers will come down. And the big reason for that, I think, is the $215 fee. And that being said, I think the companies should not wait until the last minute. March 24th is the last day. March 7th is when it starts. So I don't think people should rush and file on the very first day. But at the same time, they should not wait until the last minute. So try to do it maybe like in the middle somewhere around March 15th. So that way you're doing things carefully, making sure all the data is accurate, and finish the registrations. And just because I think the numbers will be lower than last year, I think the selection percentage, the selection chances more than likely will be a lot better than last year. And I think people should just, I think, look out for the lottery once it is done. They have 90 days to do the actual filing. And we have cases where people wait until the last minute and then they miss the deadline. So getting through the lottery next month, that doing it cleanly with the right data, that is very important. If they're selected in the lottery, remembering that there is a 90-day deadline, and again, not waiting until the last minute, but doing it a little early than the deadline and wrapping it up, that's also pretty important. And hopefully, I mean, again, at this point of time, we are not really seeing like denials or anything for H-1B. As long as the company is legitimate, the job is legitimate, USCIS is still approving cases. And President Trump's administration, they're also saying that they're not really in favor of doing anything to H-1B. Yes, they're talking about changing EB-5 and other immigration things out there, but in terms of H-1B, most of the administration officials, they're coming and saying H-1B is valuable, and they don't have any plans of removing H-1B or making any drastic changes at this point of time. So hopefully, I think people get selected in the lottery and they get through and use this as a part of their career and move ahead.
Absolutely. All the best folks out there, especially those who are going to, try their luck in this H-1B lottery this season. So thank you once again, Chand. It was such a pleasure and an honor having you here on Immigration Talk Show. It was a great discussion and a very insightful one. So thank you once again.
Thank you,
Have a great
Nipasa.
day. And folks, do check him out and also check us out at Immigration Talk Show. Do not forget to also, check us out at www.staffingly.com. And you can also email me. My email address is nipa@staffingly.com. You can also WhatsApp me. My phone number is 408-335-6444. This is also where you can call me and message me on WhatsApp about your case or questions. So thank you once again. Folks out there, have a great day and stay tuned on Immigration Talk Show because we got more webinars lined up. Thank you for joining us.